She's advised and published on labor law and its application to informal and non-standard workers, as well as business and human rights for the last 25 years. She advised the Thai Ministry of Labour on how to enforce the Home Worker Protection Act. And her most recent book is The Living Wage, which was published by Oxford University Press. Then we have Zehra Khan. She's the founding General Secretary of the Home-Based Women's Workers Federation in Pakistan. It's the first ever trade union of home-based workers in Pakistan. And as someone from Uyghur who has witnessed this remarkable process, I can say that it's because of her tireless efforts that the Sindh Assembly, that's a province of Pakistan, passed the historic Homework Act in 2018, the first of its kind in South Asia. We are very fortunate to have two people from the Australian Construction, Forestry, Maritime, Mining and Energy Union. Vivian Wiles is the Senior National Industrial Legal Officer and Coordinator. She has worked as a Union Industrial Legal Officer since 2000, including 18 years with the Textile, Clothing and Footwear Union of Australia, up until its amalgamation with the CFMMEU in 2018. During her period with the Textile Union, Vivian was actively involved in the community campaign to introduce the necessary reforms to the Federal Work Act 2009 that have enabled the protection of industrial outworkers. And then Beth McPherson has been working for the National Union in the textile and footwear and the other one, of the clothing industry, in the capacity as a compliance officer for over 20 years. Beth began with the Textile, Clothing and Footwear Union of Australia, until it amalgamated with the CFMMEU, and she now works as a compliance officer of the CFMMEU's manufacturing division. Beth has been involved in the development and compliance auditing processes for the Home Workers Code of Practice. So we're going to have this in the form of a panel discussion. The discussion will comprise 3 questions for each speaker, and thereafter panelists will respond to your questions. So please, if I can ask you to write your questions in the Q&A. You'll find it on the right-hand side under the More. If you click onto that, you'll see there's a Q&A button, and please write your questions there. You can write your questions as panelists are speaking, and they're fresh in your mind. So we've got 3 questions, and the first one is about, as we all know, legislation doesn't just happen. It's the outcome of struggle by workers. And so I want to start with you, Shelley. Could you tell us how the Thai Home Worker Protection Act came about?
Well, first of all, thank you so much for having me along, and for all the fabulous organizing Malays and the interpreters who we can't see right now, but thank you for all your work, and Balance as well, who's in the background with the technical aspects of things. So like I think any legislation for home workers, the Home Worker Protection Act in Thailand was extremely hard won. It took many, many years of campaigning, primarily by the home worker organization in Thailand, who we know as HomeNet. It has a Thai name. And really what they did was present overwhelming evidence about the number of home-based workers in Thailand who number in the millions. So in a country like Australia that has a small population relatively, and we have so much fewer, but it's really a major aspect of Thailand's economy. Is people working in their homes, linked both to export industries and also to internal, really important internal industries. I'll stop there and hear about the struggles in other countries.
Great, thank you. And So Vivian, the Australian art worker legislation is the first supply chain legislation in the world. Can you briefly tell us how this legislation was achieved?
Thanks, Marlies. Hope you can all hear me, and I echo Shelley's thanks for organising the webinar. It's a fantastic opportunity. Well, look, it's a similar story in a way. Australia might be a Western country, but outwork is absolutely fundamental to the clothing and textile industry in Australia and has been for many, many decades. And it really was similarly a decades-long struggle to amplify or to show the position and situation of outworkers and their appalling wages and conditions, and then think through the best way to regulate the phenomena of outwork. So in 2007, a relatively progressive Labor government was elected federally in Australia, and that was kind of the first opportunity after 11 years of very conservative government to try and get some legislative change. There had been pockets of reasonably good state legislation in a couple of states, but there really was no national regulation dealing with outwork. So it was a long campaign. It involved the union. It involved community organisations and activist organisations such as Fair Wear, community organisations such as Asian Women at Work, and of course, active groups of outworkers as well, who also were involved in the lobbying. Similarly, the legislation was fiercely opposed by the opposition government and also much of the industry, who thought the world was going to collapse if outworkers actually got a minimum wage. But we pushed through, and eventually the legislation was passed. So it was historic, but it really was, I have to say, it's probably a 25, 30-year campaign to get to that point.
Wow, it's such a good reminder that it takes 25 to 30 years.
It's a bit depressing, really, but yeah, it's like the window. You kind of have to grab it and be ready to go with it and push very hard.
So maybe if we've got time at the end, you could talk to us about what those windows were, in the question and answer section. So just moving to Zara, on the 29th of May 2018, the Governor of Sindh signed the Sindh Home-Based Workers Bill into an act. And this act is the result of more than 2 decades, so again, 20 years of work by the Home-Based Women's Workers Federation. Zara, can you describe how the Federation went about organizing home workers, and then describe its campaign and advocacy strategies?
Okay. Thanks, Marlies, for inviting us to share our success and struggle with you all. And the second thing which I want to make correction, it's not by the governor, it's by the assembly, the provincial assembly. So this is the highest body in our country who passed the legislation. So I will try to make a short presentation of the whole work which we are doing, which we did basically. The general rule of the world is that the legislation or the legislative process come at last. The law comes at the time when the specific issue becomes so important as a result of the struggle somewhere within the whole society that there is no other choice but to accept it. So, and I think the society that are more democratic and positive, in which a question arises and it's resolved. The society we lived in, no one is ready to listen unless there is a cry or a shout, and sometimes there is an attempt to suppress this cry and shout, and also cap this issue or the issue arise by making law and make people silent. So it doesn't matter for them, for the legislator, if it is implemented or not, or who will follow the law. Therefore, even after the enactment of this law, a big question arises on its implementation. We have been constantly fighting and struggling for the recognition of the home-based workers for more than...
Sorry,
Hello?
we're going to talk about the enforcement a bit later. I wonder if at this point, sorry, if you could just
Yeah,
talk
I'm
about...
going to this. Yeah,
okay.
yeah, I'm going to. Okay. So we have been constantly fighting and struggling for the recognition of home-based workers for more than 16 years. At that time, we were the only who said that the home-based worker is a labor and a class issue, rather just considering it a gender issue. And the issue should be seen from the perspective of labor, in which the most oppressed part of the labor force is are the women workers. Therefore, women home-based workers have been placed at the bottom of the entire supply chain as they stay at home. So they were not only under the social pressure, but even they could not organize themselves because of invisibility and scattered nature of the work. So the more they are down in the supply chain, so more they are oppressed. But most of all, it was a difficult task for us to organize these workers and bring them to the part of consciousness level. So we started meeting and study circles with these home-based workers in different areas. And when this stage is over, legislation is no longer a difficult work for us. So as a result of continuous work, home-based workers also become organized and prepared for the struggle. We came out on the street, staged demonstrations, held press conferences, state lobbying with the legislator. As a result of this, all this, the legislation has been passed in 2018. Even in this struggle, three of our comrades were also died, who went to remote areas to organize women home-based workers and got into a road accident. This is why we are saying that our blood is also involved in this, the whole movement and struggle. Here in Pakistan, because of huge number of women presence in the sector, it was raised as only women issue, as I said, by the civil society and the human rights organization. I think there is some.
Can I jump in and just ask you to, so this is, amazing way of organizing through study circles and then cooperatives. And I think people would be so interested to hear how these study circles worked. How did you begin, what this conscientizing process that you spoke about to shift to and positioning this as a working class issue? I wonder if you'd mind telling us a bit more about that.
Yeah, there is an issue with my camera. Is it okay if I off the camera? Okay, fine. Thank you. So I was saying that the civil society organization took it as a women issue, or they are oppressed, women are oppressed, and showing their sympathy with these women. So that's why initially some people said that they should be made entrepreneur, or some people said that they should be taught to market their product for sale or need market spaces. At that time, we took a new path and different ideology. We took the different part and different ideology, and thought that it is the work of the informal sector and also a huge labor force and the most oppressed section of the economy as well. So they should be recognized as labor and get their due share and rights. We started working on it very slowly by visiting different places which is linked with the industrial zone. We went there, met with those women door to door, visited their home, and bring all those women at one place to listen us that what we are saying to them and why we are organizing. We want to organize these home-based workers. So, and begin the struggle for the legal position. Because the workers are linked with a different level of the sector within the informal sector, there is no single sector, you can say, the specific work they work. These workers are also work for the factories, for the local factories and for the international brand as well. and they are also the self-employed workers. So where there is their original owner, because their original owner is not visible and do their work through the contractor and subcontractor and even by the middleman. So we thought of doing something for them so that they could be recognized as labor and get their right. At the same time, at the time, we did a great job of changing the definition of the centuries old workman, employer, and the workplace. These three definitions we worked initially, that this should be changed and include the home-based workers or the other informal workers, that they can also cover under the law, which was the colonial, you can say, the period definitions. And because of these three definitions, the category of labor was defined here in Pakistan.
Thank you very much.
So
Sorry,
these home-based workers were, which is why they don't even fall in the category of old definition. So instead of moving on the old and general law, we started talking about the need to make special law for them, because it is not 10,000 or the 5,000 workers, but millions of workers who are engaged with this sector and increasing rapidly in Pakistan. We also saw that the ILO convention protect us as well, like the C-177 convention, which is the only convention for the home-based workers. So the issue for Pakistan is that when we started this work, there was the duality in the, like we have the federal law as well, and we have the provincial level. So before 2010, we had to form the law at the provincial level as well and the federal level as well. So there was an ambiguity in the law. And even that time, many at the time, the organizations, different organizations who are working for the home-based workers' right and labor right and within the civil society organized said that it was a federal issue. So we have to go for the federal law. But we were the only in those meetings and in programs that we said that we should go where we have the power and where law can be made easily, no matter it will be at the provincial level or anywhere. Therefore, after the amendment in the constitution in 10, the labor law become the regime of the provincial law. So it gave us a chance to work through the provincial level, and then we will ask for the federal government to make a law. Then we get the chance to say that the legislation is needed at the provincial level and not at the federal level. So we started it from the Sindh province. At that time, there was no national policy, so there was no legislation on it. At that time, we talked to the largest political party in Sindh, so they put in it in their manifesto as well, that they would work on the home-based worker issue. But that time the party leader was alive, but she was later assassinated. Her party had an emotional impact on all the words she was said previously. So I think the main reason the Sindh initiated this legislation was that commitment which is done by the dear leader of that party. And even the struggle which we had did here. So these all things, you can merge it, and then we say that this legislation was. But there is another thing as well. Like I said, that we were organized in Sindh, we were talking to the legislator, we were sitting in the tripartite body, so it was easy for us to make a law. But long before the legislation, where we were organized and visible. So now we have done all our struggle or our work in threefold level. First, we organize meeting and study circles with these home-based workers to aware them that how they are exploiting in the capitalist system and what is written in the law and what we have to demand. The second part was to organize these home-based workers into union or any form which is visible for that. So we organize these home-based workers and we use the existing law. Like we have used the constitution right, the Article 17 to form a union and our federation. And formed our union and federation, and then succeed in forming our federation, because in Pakistan we have law that if you have the two unions from the different, even within the one province or within 2 or 3 province, you can go for the federal level to make or to register ourselves as a federation. So we formed 3 unions that time in 2009, and then we have also formed the federation, Home-Based Women Workers Federation, and get registered from the NIRC, is a National Industrial Commission in Islamabad. It was a big event and success in itself, that there was no identity, and even the law, but we got the way out from the existing law and form our unions and federation. It was a multi-dimensional task, and we are working on each level simultaneously. We worked at simultaneously on the each work. Like we organize at the same time, we are organizing these home-based workers in their areas and the different communities, but we are also forming the unions and federation, and then we are also working on the legislation process, and we are lobbying with the. So this was the multi-dimensional task which we were engaged previously. On the one hand, we were organized, like I said, we are organizing the workers in their areas. We were protesting as well. We came out on the road, show our visibility that we are exist in Pakistan, because previously, whenever we talk about the home-based worker, the ministers and the legislators saying and asking us, where are these home-based workers whom we are talking about? So we decided that to come out on the road and protest and shout on the road that we are existing in Pakistan and you should make the law for us. We formed union and federation, and we are also.
Sarah? Sorry,
Hello?
I'm going to ask, Zira, sorry, I'm having to chair tightly because I want us to get to the meaty part of each of the pieces of legislation. So if you can just tell us if you've got one more sentence, if you want to just wrap up so we can sort of move to the second and third question.
Okay.
Anything else you want to just leave us with?
Just one thing, that we are making a movement and we are using the law to register these home-based workers, and we are working on different level now.
Yes, and thank you. We're going to come to that in our third question, just hearing the different level that you're working at. And thank you just for setting out so vividly these multi-stages of what it takes to struggle for a law. I mean, I'm stuck with this picture of people dying in accidents as they go to far-flung provinces to organize, and the methods of organizing through study circles and then cooperatives, and then using the law, as you said, the constitution, to claim the right to register as a trade union, which then permitted you to be able to participate in the tripartite structure. We're going to see some wonderful photographs later on of just the numbers of women that we're speaking about. And perhaps also just to say, these women are across many, many industries. I want to just, something I should have perhaps said at the beginning is that home workers are contracted in different ways, partly depending on the industry, but also the country. So, for example, in the clothing and textile industry in some countries like India, you'd have tier 1 factories who would subcontract to tier 2 factories, and a tier 2 factory could contract directly with a home worker, or otherwise subcontract to a bigger workshop, which would go to a smaller workshop, and then to a home worker. So there are multiple ways in which home workers are contracted into the value chain. And perhaps, you know, in the question and answer, some of my colleagues on this panel could talk some more, or the panelists in particular countries. So I want to move now to the unique features of the legislation. We're going to discuss Thailand and then Pakistan, and we've specifically given a big slot of time to Australia because it's such an incredible example. It's unique in the world of getting the supply chain perspective right. I know that the colleagues who will be listening to the recording from the Clothing and Textile Union in Uruguay, where they've got similar legislation, but have actually struggled with the implementation. So have been very keen to hear this. So Shelley and Zara, I hope you'll excuse me if I ask you to keep this to our allotted time, and if you don't mind if I sort of just prompt you, because if you like me, you get carried away, so that we can give enough time for this Australian example. So let's, we're going to start with Shelley. If you could tell us, what are some of the unique features of this incredible legislation in Thailand? What are the aspects of the legislation that were fought for and why? At this moment, I'm going to ask Valence just to share his screen, because we're going to do this section with slides just to make it easier to follow.
While Valence is getting that up, I'll perhaps just say a couple of introductory things. So with home worker legislation around the world, Valence, can you move to the next slide? Some of the legislation modifies the existing labour code, and some are separate pieces of legislation. The Thai Act is its own separate act. So even though it doesn't expand the existing labour code, I guess the biggest thing that it does is it recognises home workers as workers. And this is really important because they really weren't recognised as workers because it's predominantly women carrying out homework. It was often, and I see this in many countries, considered to be something that women were doing on the side, even though often these women are the main breadwinners for a family. It requires documenting of contractual terms, which is so important because this work is generally informal around the world. It requires the payment of no less than the minimum wage, however that's whatever that's set at, which is legislation, and it provides liability of a hirer, so somebody who is potentially a step removed from the home worker, and also really importantly established a tripartite homework protection committee, which has home worker representatives, it has the business council, and it has the government on it, and they can make regulations with regards to home workers. But there are a few deficiencies, and I think setting this up and speaking to the point that Marley's just made about complex supply chains, it doesn't address the complexity of supply chains, particularly in the way that Australia, the Australian Act does. Valence, could you move to the next slide? So as Marley's was saying, most workers work within complex supply chains, and that means that it's far more difficult to grant them their rights than it might otherwise be. And it really requires additional features of an act, whereas the Thailand Home Worker Protection Act is like a modified labour code. It only has some of the things that labour codes normally have. So it doesn't have the full rights to the labour code. It doesn't have the right to give workers the right to collectively bargain, which is a really big problem, and we'll be able to see the difference between this and Australia's and Pakistan's Act. Workers don't get any information about their rights through this, and there's no requirement to register work contracts either. Next slide, Valence. But really the biggest problem is that it doesn't reflect the complexity of supply chains. So in the fishing industry, for example, there's normally a factory. The factory there's normally an employee who gives, who's a former employee who's kind of managing out workers. They'll pass the work on to a subcontractor or to a person in a village, and that person will then pass the work on throughout the village. Within the clothing industry, it's way more complex than that. there's a body, there's a firm, they call it the cutting floor as a direct translation in Thailand, who designs, they pass it on to a hirer. There could be a few more steps, and then it gets to the home worker. And so the big problem with the Act, Balance, next slide, please, is that it only allows for the hirer, as it's defined in the Act, so just that one step up from the person in the village who's handing out work to relatives, it only allows that hirer to be held liable. And often that hirer is just a person. They're not a company. They're not somebody with power. They could just be, as I said, a former employee or of a factory who's handing out the work. So the problem is it doesn't get to the factory. And that means that even if the Act is enforced, it's not getting to the person with money or the person with power who can actually remediate the home worker. Thank you.
Thanks very much, Shelley. We're going to pick up on some of the aspects you mentioned here. I wondered, just one thought I did have was, there was another feature, I think, which was interesting, that if it's if a home worker wants to go to court, then and it's in the interest of all home workers, the state will support the litigation, and the judge is instructed that if the contract gives undue advantage to the hirer, that the judge, he or she, should ignore that provision. Is that correct? And I wondered if you wanted to say something more about that.
Yeah, that's right. It's a really important feature, and mainly because, you know, it's so hard for a home worker to bring a claim. It's so hard to put together the evidence, especially when there is no, normally, you know, there isn't paperwork, there's no paper trail. And so anything that makes it easier is so important. The problem is it's just never been used. So that particular feature is great in principle, but not useful without the Labour Inspectorate actually deciding to take action themselves. So it, you know, it requires it's the Labour Inspectorate who needs to do the enforcement, and would in principle receive this funding to take the legal action, but they're very reticent to do so.
Exactly. Well, thank you for that. And I think that's why it's so important today for us to give some time to the Australian model, which goes further than the hirer. So I want to turn now to Zara. If you could tell us, what are the principal features of the Act that home workers have fought for? And Valence, you'll just upload her slides. Thank you.
Hello, am I audible?
Yes. Valence, yeah, brilliant. Thank you. Go ahead, Zara. So Valence, you just need to put her slides on. Sorry, Valence, won't you just, she needs her slides, so it's the next slide on that.
All right, going to now. Sorry.
Thanks.
Okay, I will just discuss 2-3 most important things for which we fought, and we put all things in the law. The first thing is that, as Shelley said, that we got the recognition. The home-based workers get their identity as a labor and their contribution in the Pakistani law. The first thing is that. The other thing was the registration of home-based workers with the Labour Department, and we have made all the procedure. We have create a form for them from which they can fill up their form and submit into the Labour. They get their registration card as a label, and then they can proceed for other benefits. The second part was, the important part was that this Act guarantees every registered home-based worker entitled to all those social medical and maternity benefits, compensation, marriage and death grants as are available to other industrial workers under the labor law. This is the second most important part for us. The third most important part is the minimum wage, because you know that the many home-based workers don't have the same wages. Even it's different from the area to area, even district or the city as well. So we are demanding that the all workers should get the minimum wage at least, or there should be the fixation of their wages. So we attach these home-based workers with the Sindh Minimum Wage Act, and I'm also member of the Sindh Minimum Wage Board. And the fourth and most important part was the conflict resolution mechanism. That in this law, we have formed the arbitration committee. And if the home-based worker is not satisfied with the decision of the arbitration committee, then they can also proceed to the higher court for the remedy. So this is the main thing or the key point of our legislation for which we have fought, and we are working on it. And the last part was the coverage under the social security scheme, that these workers are working for the country or for the foreign exchange or from their work that the country earns, but they will not register or they will not get any benefit, only social security or the pension. So we have made this specific thing in the law, that the law should be, these social security should be the universalized one. And under this act, we have also make a fund for these home-based workers, and this will use for their benefits. So these are the main points for our work which we have done for the home-based workers in Pakistan.
Thanks very much, Sarah. I think one of the key things that I'd love to pick up in the question answer session is the fact that home-based workers are registered and have a card, which of course deals with two issues. One is some home workers would be working for different suppliers, and sometimes it's intentionally constructed like that, so that they don't fall under legislation as employees and can't, for example, claim social protection. And so it seems to me, and maybe you want to just comment on that, that if they have a card, it means it's not fixed necessarily to one employer for purposes maybe of social protection. I wonder if you would like to just comment on that.
Yes, some of these home-based workers are working for 2 or 3 employers as well. So it will benefit us in the contribution in the social security net. And the second most important part is that we are going to register these employers as well. So that's why we have made a form. We have created one form for the registration of these contractor and middlemen. So we will find many employers who are linked with the supplier, any of the big brand and or the other local big brand. So we will make them that they should pay these workers contribution in these social security scheme.
So thank you very much for that. I'd like to come back at the end to, if there's time in the questions, to the issue of minimum wages, given that home workers are paid by the piece, and how we both, to get your thoughts and Shelley's, and then also maybe to look more closely at these tripartite structures, or well, in your case, the appeal board, and then that committee that Shelley spoke about. But I want to now give the floor to Vivian and ask you, Vivian, to take us through the Australian legislation. So Valent, if you could just put up Vivian's slides. Thanks.
Thank you, Marlies and Valence. Probably just a couple of introductory comments. One of the, and this won't surprise anyone, but really one of the main ills that the legislation was really trying to fix, if you like, was the sort of systemic phenomena of sham contracting of outworkers in Australia. So that the classic sort of artificial divide between who is an employee and who is a supposed contractor, someone running their own business. And the union's experience of that and trying to deal with that essentially meant that we were trying to use a system of regulation that only dealt with employees and was constantly trying to fit outworkers into that system. And we were constantly facing the situation where we were told that those people had no rights and therefore they had no remedy. So that was the sort of key thing that the legislation was really trying to address, was to pierce sham contracting for outworkers. So if we go to the next slide, Valance, please. Thank you. And the next one. Yeah. Thank you. So the legislation was passed in March 2012. It was amendments made to the Fair Work Act 2009, which is the Commonwealth federal legislation. And it introduced specific protections and rights for outworkers in the textile, clothing and footwear industry. So it was limited to outworkers in that sector. And there were essentially the amendments as outlined there really it was 4 key things. One was to essentially deem contract outworkers to be employees for the majority of purposes of the Act. And this was really the critical lever in terms of piercing sham contracting. The second thing was really to provide a mechanism for outworkers to recover unpaid amounts that were owed to them right up the contracting chain. The third thing was to really enhance union right of entry so that we could more effectively enter premises, in particular sweatshop premises, to investigate breaches of outwork conditions. And the fourth thing was to introduce basically a federal code of practice that dealt with TCF outwork. So that was the broad architecture, if you like, of the amendments. So Valance, if we go to the next slide, please. And so a whole new part was inserted into the Fair Work Act, Part 6.4, and special provisions about TCF outworkers. So it's very explicit. And the objects are very important because they really illuminate the parliamentary intention in what was trying to be achieved. And we really loved the first one, which was to eliminate exploitation of outworkers in the TCF industry. And to ensure that those workers are engaged in secure, safe systems of work. And the third point is really important too.
I'm just wondering, it seems.
Can you hear me?
I can hear you.
I can hear you.
Oh, good. Okay. I couldn't, I think I heard Marlies was asking something, so I didn't know whether she could still hear me. So I'll continue on. So the third point is that to really create nationally consistent rights and protections across Australia, as I said earlier on in the webinar, there were some quite good pieces of outworker legislation in certain states, but there really was no federal consistent set of rights. And then again, as we talked about, creating the mechanism for recovery of money up the supply chain and the code of practice. So the sort of key reform, so that the deeming of contract outworkers to be employees. So it's important to know that outworkers, so employee outworkers, already had the majority of rights under the Fair Work Act because they were considered employees and therefore were entitled to the minimum terms and conditions and the other rights under the Act. Valance, we can go to the next slide, please. So, so in terms of deeming, what it does is that it essentially says that if we have a contract outworker, whether they're legitimately a contract outworker or a sham contract outworker, the Act says, well, it's really irrelevant because we're going to deem that outworker to be an employee for the majority of purposes of the Fair Work Act. It also deems the person who engages that outworker as an employer. So it's like this sort of legal, it's kind of legal fiction, if you like, but the effect of it is that whether someone, whether an outworker is an employee outworker or a contract outworker or some other version of outworker, the legislation essentially treats them as a worker who has rights as an employee under the Act. And so that's critical because through that deeming, all the minimum terms and conditions under the Act, the minimum wage rates, access to unfair dismissal and other general protection remedies and collective bargaining then flow to the contract outworker. So what that means is virtually now not every, there's probably some very small percentage of outworkers who now wouldn't be covered by this legislation. I won't go into too much detail, but there is a sort of exception in Western Australia for outworkers who are engaged by what's considered to be a non-constitutional corporation. There's some doubt about whether they might be covered, but it's a very small percentage of outworkers. Valente, we can go to the next slide, please. So the second major part of the reforms, as I said, was to create a mechanism where an outworker could take steps to recover unpaid amounts owed to them up the supply chain. And I should say that from the union's experience, TCF industry supply chains in Australia do tend to be quite long in most cases and quite complex. So they're often wide and long supply chains. And as Marlies was talking about before, they could be 3 or 4 contracting levels, from the sort of fashion house right at the top and the brand right through to the series of subcontractors down to the outworker working at home. So this mechanism it's framed around acknowledging that there is a person or some entity that directly engages the outworker and they are the responsible person. But it also acknowledges that within the supply chain, it could be one or more indirectly responsible persons in that supply chain. And as we know, often outworkers or home workers at home, they don't have plain sight as to the supply chain. All they really know is who gives them the work, and they might know the brand that they're working for because they're sewing that label into the garment, but they really have no idea about the complexity of the supply chain necessarily. The recovery mechanism, one of the good things about it is that it has a very broad definition of what constitutes an unpaid amount. So it can be anything from unpaid wages or leave entitlements, superannuation, payment for reimbursement of materials, for example. And so the way that the recovery mechanism is intended to work is that if the outworker is not paid by the person who directly engages them, then they can then claim against the indirectly responsible person or persons. Where there's more than one indirectly responsible entity, then those entities that this provision deems them to be jointly and severally liable for the payment of the unpaid amounts. So Valente, if we can go to the next slide, please. So as I indicated, the practical effect is that it is a mechanism where the outworker really can jump over the person or the entity that directly engages them if that person or entity fails to pay them what they're owed. In the legislation, there's quite a detailed process of recovery that involve about 6 or 8 steps, but essentially the outworker or the union or an inspector can make a demand on an indirectly responsible entity. And if that person fails, then they can go to court and seek an order to that effect. It's still a complicated process, but I think Beth can talk about the importance of this provision later in terms of the leverage that it gives the union and outworkers in terms of getting paid what they're owed. If we can go to the next slide, please. So the third sort of major part of the reform was this capacity of the federal government to legislate or regulate for a code of practice relating to outwork. Essentially, this federal code really was about trying to develop a set of kind of obligations on major retailers in terms of their record keeping and compliance, so that there was better visibility about supply chains involving major retailers. The unfortunate thing about this part of the reforms is that, as I said, the legislation was passed in March 2012, and then in 2013 the Labor government lost power, and at that point the code hadn't been regulated, and so we have a situation where the capacity still sits there in the legislation, but the detail of it has never been developed, unfortunately. Valence, if we can go to the next slide, please. And the fourth area, main part of the reforms, did involve improving and enhancing TCF-specific right of entry under the Fair Work Act. Prior to these reforms, there was already some TCF right of entry powers, but what this reform aimed to do was really to deal with an anomaly, specifically in relation to TCF industry sweatshops. So what I mean by that is that typically this was well, literally a sweatshop. It might be, you know, in an industrial estate behind a sort of roller door where people were undertaking work. And interestingly, what we found at the union is that it was not unusual for outworkers at home to move between outwork at home and working in TCF sweatshops outside of the home, but certainly not in the formal kind of TCF factory, and move between those sort of two environments. So one of the limitations of the existing right of entry is that for us, being the union, to investigate breaches of wages and conditions in sweatshops, we needed to have a member, and invariably we never would have a member because the level of exploitation and fear and intimidation was so extreme that no one would be willing to join. And many of these sweatshops weren't even sort of on the radar. They were literally, as I said, operating in, you know, industrial estates in the suburbs, you know, behind roller doors that often were locked, creating real OH&S issues. But we have this reform has been very powerful for the union in terms of trying to address a lot of those issues, particularly in sweatshops. So that's probably just a very quick summary of the provisions. Not sure how much time I've got left. looks like I'm nearly at my time, so I might just leave it there unless anyone wants to ask anything further at this point.
Thank you very much, Vivian. I've got 1,000 questions, but I think possibly just looking at time, best if we come back to those questions at the end. But thank you for a very, very rich presentation. I wonder, I'm going to move now just to the enforcement aspect and just begin with Sarah. Sarah, you've spoken about the implementation as a second phase of the struggle. Can you tell us more about this? You know, what are the challenges of implementation, and what is the Federation's primary strategies for implementation or enforcing this legislation?
Okay. Right now we are facing few issues because of the lack of the Labour Department willingness on the issue. So there are 3-4 things which we are working on it, and we simultaneously we are lobbying with the government as well, and even asking legislators to implement on the law. And the second way of that is our movement. We can organize once again and come out on the road after the Eid, or after if the government will not listen us, then we will again come on the road and sit in outside the Sindh Assembly. So there are a few things which I want to share. The first thing is that still in our law there is some ambiguity because what we have drafted and we have given to the Assembly, that is not very much, but few of the things were changed and amended. So we have solved the issue by formulating the rules of business on the Act, but still we need to change or amend the law, which is also go to the Sindh Assembly, and then they will pass the new law. So we have already drafted these amendment, and we have sent it to the Labour Department in August 2019. But still we are waiting for the amendment, and they didn't work on it. The second thing is the Labour Department. In one meeting, the Labour Department, all the joint directors who are basically responsible for the registration of these home-based workers are not willing to register these home-based workers. In spite of that, we have registered, we are helping Labour Department in collecting data from the home-based worker in the field. We have collected more than 7,000 forms, and we have already submitted more than 2,288 forms in the Labour Department, but still they didn't verify those forms. So still we are struggling to register these workers with the Labour Department. And now one more thing came out. Yesterday we did meeting with the Labour Secretary, and we are also supporting them to formulate or in the making of the software in which all the data of home-based workers will be feeded. So now Home-Based Women Workers Federation is helping the Labour Department to make a software for it, so the data will be safe. This is the issue which we are facing it, and if this will not solve within 2 or 3 months, then we will go for the protest. The other thing which we are waiting since the formation of this law or the passing of that law is the announcement of the Provincial Council, because the Provincial Council is the main body who will look after all the registration and mapping work. But still we are waiting that, because the cabinet is not getting clarity on, like they are again and again asking with us that you have to ask your employer, your contractors, that they have to give their nomination on the registered number. And look that still the home-based workers is not registered. It means that their employer is also not registered. And this is the first time we are registered these home-based workers and even the employers. So how we will give the government the registered number of their employers? So that's why we are still debate with some legislator on this, and we have just cleared all this issue. see when they will announce this provincial council, which is the main thing which who will help in the registration process. The second thing is that the governing body, and governing body has the power of the fund. How we will use that fund, from where we will collect the fund, and how much the government will give us. Only one meeting was called. The governing body was announced in 2020, and the first meeting was held in February 2022, and that was adjourned without any decision. And in the same meeting, all the joint directors said that they will not register these workers. So now we are thinking, in our federation, that we have to go on again for the struggle, and we will go for the petition in the High Court against the Labour Department. If it will not solve within 2-3 months, then we will go for it. The other issue which we are facing, that we are talking about the universalization of social security scheme, and we have success in this as well, because we have amended the provincial SESI law. SESI is a Sindh Employees Social Security Institution. So we have amended and we have created one definition. It's the universalization of social security scheme. Through this definition, now all the workers in the Sindh can register themselves with the social security scheme. But the contribution is still the issue, because the contribution is they are asking for the 1,500 per month, and home-based workers whose earning is 700 rupees or maximum is a 4,000 rupees, and they will give the 1,500 rupees per month to the as a contribution. Then this will make the issue for the home-based workers. Then how? Because the home-based worker will see that the money will use in the home for their food consumption and other things which they need on the daily basis. So this is the issue, and still we are discussing with the minister, basically, that they have to, and even with the one political party's chairman, we have discussed this, and he has recognized this issue, and he said that we are saying the right thing, and but still there is no meeting that we have to decide how much percentage these home-based workers will contribute in the social security scheme to get the benefit from the government. So this is still the issue for us. So these are the loopholes. Like I said, that that we think that the organization is the most difficult thing, but now we are thinking that the law making and the implementation is more difficult than the organizing. So still we are working on it, and we are very much enthusiasm that our workers is very much keen to go for the protest again and organize themselves to get the benefit.
Thank you very much. I mean, it was, I don't want to add anything to take away from what you said now, but I think you do touch on the complexity of enforcement.
Yes.
Which leads me to Viv. So Viv, I wonder if you could, how successful has the Australian model been in ensuring decent work for home workers? And what are the challenges in enforcement? And perhaps if you could share in a more sort of granular detail than Beth in her overall presentation, what the enforcement strategies are. So she talked about the investigative powers of the trade union, but if you could talk us through it in a little bit more detail.
Sorry, Marlies, I couldn't hear you properly. Were you talking to me or to Beth? Oh,
to Beth. Sorry.
Oh, to Beth. Yes, that's right. Yeah, okay.
Okay. All right. Hello, everyone. I really appreciate the opportunity to be able to share our experiences because it has been a very exciting time. And as Viv's outlined, the laws have definitely assisted greatly in the work that the compliance team do in the supply chain mapping and the rectification of outworkers' rights at work. So the other thing that I just want to note is that in addition to the laws that Viv has identified, there's some more detailed obligations that are imposed on companies that sit inside the Textile, Clothing and Footwear and Associated Industries Award, which is another industrial instrument that is used for the protection of outworkers. And that allows us to do some very detailing detailed mapping by obligations on companies to provide their full supply chain to provide transparency. So this identifies where the outworkers are within a supply chain, and what happens generally is that it also identifies outworkers that weren't known to the supply chain, the top of the supply chain earlier, so the fashion houses and labels and brands. So as we go through the investigation of the supply chain, we normally identify a whole range of other outworkers within that. So I just want to touch on a couple of tools that we use to assist in our enforcement. So one of the tools we use, we call value and volume. So this traces all the work that's given to every individual company from a fashion house or label or brand. That allows us to apply a formula that tells us how many workers that particular factory needs to complete that work from that label or fashion house. And so what that allows us to know is how many equivalent full-time workers based on a 38-hour week, which is the legal hours in Australia, that are used to perform that work. The company then needs to provide us with the details of every single worker. So if they've only got 5 workers inside the factory and our calculations show that there's 12 workers, where's the other 7? They have to identify that to us. And generally, we find that they're outworkers. Before we started doing that value and volume checking, it was very difficult for us to understand really how many workers were required. So what would happen is we'd turn up to a factory and the factory owner would say, things are very quiet. We've only been able to use these 3 workers. And we had no way of actually verifying whether that's true. So by getting the value and volume information, which is the amount of garments given to the factory, as well as the money value to those garments, and the minute rates, so the time that it takes to complete those garments, that allows us to get the total number of workers. Another really important and successful part of the supply chain strategy is what I call the two-prong approach. So the compliance officers, that they're dealing with the top of the supply chain. So that's the fashion houses, labels, brands, etc. But at the same time, we have the outwork outreach team meeting with the outworkers. So if you like, the compliance officers go from top to bottom. At the same time, the outwork outreach officers are going bottom to top. So it allows us to collect a whole lot of information all at the same time and be able to match it up and see whether or not it equals. And most of the time it doesn't. So it's really, really valuable information for us to be able to understand exactly what's happening in the supply chain, and be able to get a better understanding about what rectification implementation that we need to take. What Viv touched on earlier is that we're able to use the supply chain, the top of the supply chain, so the fashion house, etc., as leverage to correct the non-compliance within a supply chain. So what we do is we say to the, if the outworker is being underpaid, which generally they are, or they're not receiving their annual leave, or there always is some form of non-compliance, if not total non-compliance. And so we try to rectify it at that level, the person that's giving them the work. If we're not able to fix it there, what we say to them is that we'll get the work cut off from them, and then we replace the outworker somewhere else. And if we can't get it, if they won't do that, if that threat's not enough, then we'll go to the top of the supply chain and say to them, and we'll name and shame them, and do them brand damage or threaten brand damage, so that they will rectify the problem. Obviously, we always have the opportunity to go take them to the federal court based on the legislation that Viv has outlined. But it's usually dragged out. It's usually a long process. It's outworkers are sometimes reluctant to go down that path. They're fearful, the ramifications, the black banding within the industry. And so what we're trying to do is fix it without having to go down that path. So we use whatever leverage we have. It's worked really, really well over the last couple of years, where we've been able to get settlements for outworkers without having to go to a court process. It's important to note, though, in that process, we've got to really protect the outworker. So the outworker can be, treated poorly and be cut off the work. There's a whole lot of things that, they may be connected to the person giving them work in some way, shape or form. So it might be that they've been sponsored, they might be living in property, they might be part of their community or church. So it's really important for us to make sure that the pressure's coming from us, not from the outworker. So when we're doing the challenge to the company, no matter where they are down the supply chain, we do not mention the outworker. So we say they've got obligations under the Act that they must rectify, and in turn, obviously we get it rectified for the outworker. But if we were to name the outworker or say that we've spoken to the outworker, they are so fearful that they will be black banned, that they will be treated unfairly. So we make sure that we protect the outworker at all costs during that process. It does take a little bit longer, but it actually protects their livelihood and their employment arrangements. Also, most companies are non-compliant. So even though we've got the laws and they're great laws, we have to enforce them on a day-to-day basis. So it's not like companies are going, oh, okay, this is what we have to do. Let's all be good guys and let's all do it. That's not the reality. If we weren't out there enforcing it and like over the years taken many to court, it would be the same as other countries where companies would just do whatever and treat outworkers appallingly. So we move companies from non-compliance to compliant, and like I said, we've got various ways of doing that, and most of the time now we're able to do that without going to court, because it does take a lot longer to go through that process. I think some of the challenges in enforcement is what I just mentioned, was, that the time it takes, the protection of the outworker in it. Outworkers are really fearful of the implications of being involved in this sort of process. So keeping that at arm's length and making sure the outreach officers are the ones that are dealing with them, who speak their language, who have trust in them, is the best way forward. So I'll leave it there for now. Thank you.
Thank you. Thanks very much, Elizabeth. We can pick it up. We're running out of time, but I think the most important point for homeworker organisations and their advocates is to differentiate that enforcement obligation that you described, how the onus is on companies to be transparent, and the way that that's I think a crucial point here. But thank you very much. I want to just move lastly to you, Shelley. So Shelley, you've worked in several countries on homeworker legislation and its enforcement. And I wanted to ask you about the challenges of enforcement in Thailand, but you've touched on that in your presentation. So maybe to speak to the broader question of why enforcement is such a challenge generally, and what the labour movement could learn from the different statutory models, and also including, of course, the Australian model, which you're very familiar with.
Lance, would you mind getting the PowerPoint up again? So I feel as though the challenges have been well summarised already, and I think it's so useful to have had Zara speaking and Viv and Beth, because they're speaking from countries where workers are relatively well organised, where there are strong unions, and of course, having a strong union has required huge amounts of work over years and years and years. But in most countries, there is no union representing home workers. And so, one barrier which I feel has somehow not been present, partly because we've had these fantastic organizations present, generally, is that there's no formal union representing workers. And I can remember, well, in the 1980s in Australia, that there was an argument in Australia about whether unions should represent home workers or whether they just should be illegal. And obviously that's many years ago now in Australia, but that debate is going on in other countries now, and I would say it's one of the biggest barriers to enforcement. The slide in front of you is kind of more specific to Thailand, but I think it covers the challenges in other countries. I mean, home workers are generally have very low legal literacy. And part of that is, because they're in their homes, they're just not exposed. There aren't sources of information about rights that there might be if you were working in a large workplace. And then, as Beth just described so well, it's almost impossible for them to make a complaint. They'll never get work again. And that is, that's true across all the countries I've seen. They get branded as troublemakers so quickly. And at least in Thailand, and I think this is true of a number of countries as well, labour inspectors who might have responsibility for enforcing the law tend to be from the class and ethnic background as business owners. So they have a great sympathy for the businesses and less natural sympathy for home workers. And my experience, especially in Thailand, because I was running training for labour inspectors, is that the labour inspectors just, they just know so little about how to organise, how to inspect the workplaces or enforce these particular laws. So in Thailand, I got to meet with most labour inspectors who had responsibility for this area across the whole country. They had great willingness. They were really nice people. They just didn't know the first thing about how to start enforcing the law. So they felt as though they couldn't go and inspect a house, even though they have the right in Thailand to inspect a workplace which is based in a small workshop or a house. Next slide, please. So all of this suggests that so much more is required to be built into legislation for home workers than you might have for a standard worker. But my experience has been that so-called standard work around the world has become more and more precarious, and what we see in homework is actually becoming more and more common for more workers who might not be thought of as outworkers. And so actually these lessons are really useful, not just for home workers, but for really for all workplaces, for unions as well. And so I wish that other unions and labour inspectors were listening to workshops like this, because, you know, unfortunately, there is a greater precariousness and vulnerability and individualization of work around the world. So there needs to be an empowerment of enforcers. There needs to be kind of extra powers, the right to collectively organise. There should be specialist home worker labour inspectors. It's a special skill. And really the work that Beth was describing in terms of that, all of the work that they're doing about looking at the volume of work that a factory is doing, it requires such specialist skills, and it takes years to build up those skills. So either it has to be a very well-resourced union, or it has to be a labour inspectorate that actually puts money behind training inspectors to do exactly what Beth was describing. And I certainly haven't seen that anywhere in the world. And as far as I know, in Australia, it's certainly not happening, except insofar as it's driven by the union. There needs to be incentives for labour inspectors. They need to get bonuses for enforcing laws for home workers, recognising that it's extra hard. And that confidentiality that Beth talked about is so important. Next slide. We haven't, I mean, we touched on it briefly, but it was something that was so hard. One in Australia was a reversal of an onus of proof. That the company has to present evidence rather than home workers building that evidence. Of course, in the end, workers' representatives do have to provide a huge amount of evidence, but in general, it's much harder to do so from the worker side. Anything that creates a paper trail and which makes the supply chain more transparent is so important. And I think Beth spoke to this aspect very, very strongly in terms of all of the mechanisms that do that, in terms of factories being required to provide a list of home workers and statutory declarations that they're being paid sufficiently. In most countries around the world, there's just no way to find out how many workers are being engaged by a company. And so either the option is you walk the streets trying to find home workers and use what we'd call in social sciences snowballing techniques, where you just say to one person, who else do you work with? And then you go and visit them, and then you go and visit the next person, and so forth. But that is so time consuming. So there needs to be a paper trail, and then there also needs to be right of entry to homes to do inspections, homes and small workshops without giving notice, ideally, so that things can't be cleared out, cleaned up before that inspection. Next slide. Sorry, Balance, if you could go to the next slide. Thank you. And then, and this has been spoken to a number of times today as well, there needs to be recruitment of powerful parties in supply chains. So both in terms of bringing them on side, so that they become a positive force, and also in terms of making them liable. And the Australian legislation does that so well, but it cannot only be the case that there are legal provisions that might result in fines. There have to be, I think, other kinds of incentives. So one option is that there needs to be the fear of criminal charges, or other things that companies care about, like the loss of intellectual property rights for a brand. For example, if they lose their branding, then that's really the greatest threat there is for them. Whereas my experience has been that a lot of companies are willing to suck up a fine it doesn't, unfortunately, bring about the change that you might want. And then also incentives for business and recognition. And what that looks like will differ so much from country to country. So in Australia, we have a labelling system so that companies gain some kind of recognition by having being able to display a label to show that they are complying with the Homeworker Code of Practice. But that won't work in countries where there's not a direct consumer market for the goods that are made by home workers. So in some places it needs to be something else. So in Thailand, for example, some kind of recognition from the king would be a far greater incentive than a labelling system, because a lot of, say, the clothing is sold offshore, so no one will get to see the labels anyway in Thailand. Ethical buying lists and so on. So incentives for business, and even that, is, you know, we know from Australia, it does something, but it doesn't get us so far all the way. But changing the culture and in the incentives within supply chains. Next slide. And then speaking to what's going on in Pakistan, and I really want to hear more about this, but also picking up on what Beth was talking about everything that happens before litigation, or everything that happens before formal enforcement. So Beth was saying that really, you know, they mainly, I gather, you know, wouldn't end up having to bring legal proceedings. Mainly, they're able to try to settle things, or bring a company into compliance or somewhat more compliance, because it's happening in the shadow of the law, but it's much better to avoid having to go to litigation. And I think for most home workers, you know, as we've talked about, most home workers, you know, unless they've already lost their work and they've decided that they don't want to be a home worker anymore, they're not going to do this kind of work. So localized community-based mediation and complaints mechanisms are so important. And I would love to hear more about the Pakistan model in relation to that. And, you know, it's so important, because I think for home workers, in a sense, in a lot of countries, the world is smaller. Like if the work is village based, even going to a town which is 10 kilometers away and having to seek assistance is a really big barrier. The cost of transport, for example, in Thailand, just to get to the local city is more than a week's wage for a home worker. So there really needs to be localized solutions, and there needs to be informal solutions where mediation can occur or a complaint can be made that isn't legalized, I think. There's a few suggestions, but I would love to hear from others on the panel.
Thank you very much, Shelley. I'm conscious we reached the end of time, and all of this is so incredibly rich, and there are no unanswered questions in our chat. And I'm sort of torn, because I think there's so many important things to follow up on. So, you know, perhaps we should end here, but I think what has come out of this, certainly for home worker organizations across Asia, is we really would like to dig deep here. I mean, all the panelists have offered, all five of you have offered such rich engagement in terms of the kinds of things that need to be fought for. And I think particularly this section on enforcement was so very interesting. So thank you very much to our, sorry, I'm just looking at the chat quickly. So we'll definitely follow up. And just to say that this was a very bad time for most ILO members, as in that they're in the Americas and all parts of the world. So this recording will be distributed both by ILO and by WeGo. And I know many people in the Clean Clothes campaign are also very interested in homework, and particularly around the legislative piece. So just to let you know, that will be going around the globe. Thank you so much to our interpreters. Thank you very much to Valence for hosting this, to Kritika and Laura for recording, and of course to our 4 panelists. It's been a marvelous opportunity and an honor for me to be facilitating this. Thanks, everyone.
Thanks, Marlies. And thanks, Valence. Thank you.
Bye.
Bye.
Bye.